All right, good morning. So we stopped at page 649 last class, which is slightly before the second half of the readings. You'll recall we're still in the chapter of public policy. So looking at the residual exemption that courts can apply in declining to enforce a contract that otherwise has been validly formed, right? So first you go through offer acceptance and consideration. You find that a valid contract's been formed. Then you look at the various nominated exceptions that we saw, so unconscionability, duress, rate, all of these. And to the extent that none of these applies, and you have to do it in order, then the court has a residual power to decline to enforce a contract that violates public policy. And that's interpreted very narrowly. We said we see most of the exceptions that have been recognized by the courts, and it's very unlikely that new ones would be recognized on, say, an exam. So last portion is on contracts that are contrary to public policy as stated in a statute. We'll see that there's a slight distinction as to whether the statute invalidates the contract or it simply expresses a policy to which the contract is contrary. So we stopped at 649, as I said. That's the Doherty case. You have a contract for the sale of a piece of property, and there's essentially a statutory requirement as to notice of that sale, right? So government has to publish notice of that sale in some way that's stated in the statute. That isn't done, sale still happens, and then one day later on someone wakes up and says sale should be invalidated because the statute says you have to publish notice of that sale. It did not happen, right? Kind of is like a mandatory condition, as we'll see later on in this class. So contract should be invalidated because it doesn't meet that necessary condition that is precedent to the formation of the contract. And you have quite an extensive discussion of why the court declines to invalidate the contract on that basis. First, as I said, it's raised much later on. We'll see that that's a pattern in a lot of the cases that we cover for this class, right? Courts are very reluctant to use these exceptions in both enforcement of contract and in assessing breaches or damages when it looks like they are being used strategically. So here, when there's time that elapses after the contract's been signed, right, it kind of suggests that that person isn't happy with the contract that's been duly executed and is trying to find a reason to invalidate it and resorting to the claim about the statute for reasons that don't really have anything to do with the statute, right? So they don't really care about the notice not being given. They just found a formality that hasn't been respected that they think can allow them to invalidate the contract, which they want to do anyway for other reasons. So the court looks at the circumstances, the purpose of the act, and trying to enforce it, right? These are principles of interpretation that we briefly mentioned that we see in both contractual interpretation and statutory interpretation, right? So first thing you do is you look at the specific provisions. If it's a clause or a statutory provision, you try to interpret it by giving it its plain meaning. If that does not work, right, you look at the statute or the contract as a whole. So you look at the other clauses in the contract, the other provisions in the statute, and try to assess how you should interpret that specific clause or provision in light of that, right? Because the whole contract or the whole statute evidences an intent. In both, we are interested in giving effect to that intent, and so, right, we'll interpret the words in the clause or the provision according to the intent as it shows in the rest of the contract and the statute. Specifically there's nothing in the statute that directly, specifically voids the contract. And that distinction is important because, as we said, when there is a statute, right, whatever it is, the statute always prevails. So if the statute says your contract is void if, that is always going to apply. It's not a matter of interpretation, and in fact, it's not even a matter of public policy. It's just a matter of applying the statute. So we said, for example, in the common law, there are no specific specific circumstances that are required, specific requirements, that are required to have the formation of a valid contract besides offer acceptance and consideration. So no need for it to be in writing, for example, right? No need for the contract to give the parties specific rights. These are not requirements to contract formation. Nonetheless, the government can and does come up with additional requirements to contract formation, and then they supersede and supplement the common law, because that's how statutes work, right? They prevail. There are legislators, which are people who are elected to write laws, and so, right, whatever they say is more legally legitimate than what the judges made up over, right, 200 years from England, and so the statute prevails. We see that. I gave the example of what we call the statute of frauds, which says that contract in some circumstances has to be in writing and signed by the party to be charged. So that means the party you're trying to basically execute it against, which generally means both parties because there are mutual obligations. Therefore, right, say you're selling real estate, that's valid at common law if it's a verbal contract, because you got offer acceptance consideration, but the statute of frauds says it has to be in writing, then it has to be in writing. That means if it's not in writing, it's invalid because the statute says so. Same thing for certain statutes having to do with registration, right? That supplements the common law as well. So if you're selling a house, then it's got to be registered in the government registry. Otherwise, it is generally not invalid, but not enforceable as against third parties who cannot and do not have notice. All that to say, right, if the statute says the contract's invalid, if a specific requirement is not met, then the contract is invalid, period. No assessment, no tests, right, no circumstances. It's just invalid. These are not the statutes that we see in the cases that we cover. They are statutes that make something illegal, not the contract itself. So we saw the example of criminal acts, right? So it's going to say something is illegal. So committing assault is illegal, and then there's a contract that relates directly or indirectly to that. Same thing here, right? The statute provides for requirements of notice that don't necessarily have anything to do with the contract, right? They have more something to do with, it's the government selling something, right? Making sure that it's done reasonably, commercially reasonably, right? So the government doesn't end up selling stuff for a lot less than it's worth because there are no buyers, or because, right, people who have the requisite expertise did not know because there was no public notice, therefore they could not oppose it, right? So the purpose of the statute is not to invalidate contracts necessarily. It's just to create a requirement that has some other purpose. For that reason, the statute does not specifically say if there's no notice, the contract is invalid. If the statute said that, then again, contract would always be invalid. So then the court has to assess that objective and essentially comes to the conclusion that, first, it wasn't really relevant. So ostensibly, as I said, purpose of the statute might be to make sure that the sale is done, right, reasonably, and that people know about it. And here there's nothing to indicate that if the public notice requirement had been respected, right, so if the public notice had been published, that the conditions of the sale would have been any different, and there is no indication either of, right, unconscionability and all the other exceptions to contract enforcement that we have seen. And then the court says, 650, that therefore it's not against public policy. Again, public policy meaning a public policy, a shared, right, set of values or goals as expressed in a statute that doesn't directly talk about contract enforcement. It's not against that. Therefore, contract is valid. Court also says at 650 what I said, that the party is essentially trying to strategically make use of that to invalidate a contract that they want to invalidate for some other unrelated reason. 651, you have another category of public policy, and that is what they call a common intent to perform a contract illegally. As we saw, right, there are a bunch of nuances having to do with people doing illegal things, and oftentimes, right, that means criminal acts. First, when the object of the contract, we saw that last class, is illegal, then it's a problem. So contract for a hitman, contract for where the substance of what is being contracted for. So someone pays, someone does something. When the does something, right, the something is illegal, the contract will generally be invalid, and that's among other reasons because we can impute that to both parties. If something's illegal, you're contracting for it, both parties have the same notice of the law and therefore know or should know that the contract will not be enforced. We face a different problem when it's not the purpose of the contract. Because then the question arises, is it sufficiently related to the contract for the contract to be invalidated? So we saw that with the life insurance examples, right? So if the guy, right, goes to Bolivia or whatever South American country, right, smuggles drugs, and then he dies, and life insurance says his kids get the money, right? Life insurance company got smart lawyers, tries not to pay, and says, right, guy died as he was committing a crime, which is correct, right? But the contract's not for the crime. In fact, the contract's got nothing to do with the crime. It's for life insurance. The only relationship is, right, he died while committing a crime. And that's an example where there's a criminal act somewhere. It's not the object of the contract, because again, the object of the contract is life insurance, and that is legal. It's sufficiently remote, right, not closely related to the contract for the contract itself to be valid. That's a different way to put it, is to say for the courts not to be uncomfortable with enforcing that contract because it doesn't really relate sufficiently to something that, right, the courts don't want to get into, a criminal or an illegal act. Second distinction that arises out of the case, page 651 and following, right, Ashmore case, is that sometimes the performance of the contract is illegal, not the object of it. So object of it, I gave the example already, right? Performance is we perform the contract in a way that is illegal. So in that example, you have, right, bill of lading, right, very, very common thing that people sued on or got sued on in England in the past couple centuries, right? So the contract is for transporting something somewhere. So not in itself illegal, right? It's a contract. The performance of it might be illegal, and it might be a shared intention. So non-shared would be one of the parties, right, performs that illegally. So they load their boat too much, that's against the statute, that is illegal. Again, example of something that's not a criminal act, right, just something illegal. If you have that, then the question arises whether the contract itself would be invalid or not, because it's just one of the parties, and it's not fair to impute that to the other one. The example you have at 651 is a common intent to perform it illegally. So not a contract where the object is illegal. The performance is illegal. And if the performance is either bound to be illegal, it's always illegal, or where the two parties participate in it being illegal. They know about it, they do it anyway. In both of these sets of circumstances, the court will generally decline to enforce the contract. So that's what you have there, right? There's regulation that says, right, can't be too heavy. When you're transporting something, right, then you have lots of discussion of, right, someone was negligent, and then who knew about what, and when. Court reiterates at 652 what I said. If it's the object of the contract, for sure it's illegal. The object of the contract is illegal, the contract will not be enforced. Here it's in the performance of it, right? And because the two parties knew about it and participated in that, the court declines to enforce the contract. And you see practically what happens there. They say verdict for the defendant, right? What that means in practice is someone is suing on the contract, right? So they're saying, I want my money because I did what I was supposed to do. Court, as I said, declines to enforce the contract. So what that means is they don't get their money, right? The defendant wins. Their lawsuit is dismissed, right? The plaintiff's asking for money. They lose, right? Defendant wins, same thing, right? The lawsuit is dismissed. Their claim, they don't get the money that they were trying to claim. And that's it for the chapter on public policy. We'll be back for another video on performance and breach.